Hello.
Hi, William. Where is everybody?
I don't know. I don't know. I just went outside and I came back in,
Well,
and I'm just seeing myself now on the.
looks like the decker got dropped off for some reason.
Yeah.
Disconnect.
Look, I see your name chopped off as well.
Well, I'm still here, but
Yeah. Yeah.
um, yeah. Okay, there she is, back on again. She must have had a disconnection.
Yeah. Yeah.
Okay.
Just got in from just got into Atlanta. Say, let me just make sure I get on.
Oh, you're in Atlanta?
Yeah, I'm in Atlanta.
Oh my God, what's happening in Atlanta? Another civil rights movement?
No, no, I'm visiting my niece and grandnephew those.
Okay, wonderful, wonderful. Yeah, I know quite a few Bahamians around Atlanta
Yeah, yeah.
from way back when.
Well, it's who in New York and Houston and Atlanta now. I mean, Atlanta's always been the hub.
Yeah, Atlanta's always been the hub.
Yeah, yeah,
Uh, Houston and a couple other Texas cities
yeah.
in the fray, and then a little gang up in New York. Yeah, that's correct. And some in the Carolinas somewhere.
I didn't get to drop off that email to you on that. I think I was supposed to request a. I think you must have given me the letter of appointment or letter of retirement. Anyhow, I have to get back on track.
Yeah, yeah. When you get a moment, you can send a note.
Yeah, yeah.
Problem. Okay. Well, you know what? Two is not a quorum, but we're gonna start anyway. Let's jump right into chapter 6. I believe we were ending our discussion. That
On page
area.
on page 62.
Yeah, page, do I have a page? Yeah, page 62. Let's see.
Yeah.
Yeah, that looks about correct. Decker, can you hear me?
Second,
Okay, great, great. I was hoping that BC didn't visit you a minute ago.
what happened is I'm on my phone.
Oh, oh, that kind of technology. Okay, well, hang in there, literally. I don't know where everybody else is. Um, I guess some will join us along the way, and others are off and running where they're off and running to for one reason or the other. But we're gonna move forward anyway for Decker and William and do what we have to do. Okay, so we were talking about the trustee powers and duties. We looked at all the duties of the trustee, and now we were looking at the powers. Does anybody remember which of the two is mandatory? Duties or powers? Which one is mandatory?
Duties.
Duties are mandatory, yes. Powers are optional, okay? Even though they're optional, the trustee act provides a whole lot of powers that are available to the trustee to get the job done. I think we had gone down the list last time: power investment, power to retain investment, power of sale, if necessary, of trustee assets, for whatever reason, power to insure, to make sure that assets are properly covered from damage and theft, etc. Power to compound liabilities. I think that was William's concern. Like, why would they compound liabilities and settle claims? I suspect there are moments in time when compounding liabilities is an acceptable thing to do, but the language itself doesn't suggest that it's something that we should see too often anywhere for that matter. Okay, power to maintain. As a matter of fact, any trustee that does not exercise the power to maintain trustee assets can find themselves being sued or even removed for negligence or breach even for allowing assets to become downtrodden and all messed up because of poor maintenance. Okay. Power of advancement, meaning the distribution of funds as per the trust instrument or the trustee's discretion. Power to concur or agree with others to do whatever actions are necessary that are in the benefit, for the benefit of the trust. To employ agents of any kind to get the job done, investment managers, brokers, lawyers, accountants, whomever they need in a particular trust if they don't have them in-house to get the job done. And then, of course, last but not least, the power to apply to the courts. And they have found that to be a very valuable power in the 21st century and a very necessary power and more often used.
Mr. Wilkinson, we can't hear you.
Mr. Wilkinson,
Can you guys hear me now?
yeah, I can hear you now.
Okay, great, great. Odette,
Yes, sir. Yes,
wonderful, wonderful.
yes, yes.
Yeah, so all these powers, these fiduciary powers that rest with the trustee, obviously are designed to assist in getting the trustee's job done. Remember, we referred to Turner versus Turner of 1984, where the trustee also has the power to distribute income or capital. Does anybody remember the difference between the two? What's the difference between income and capital? Very important in this business.
Income really arises to the trust in terms of the dividend and interest that may be received by a beneficiary from the investments of the trust, whereas capital is usually it's referred to as the corpus, or what in the final, if there's a remainderment
Trust asset.
situation, it's what the remainderment gets.
Indeed, and of course, by definition, that's what it stands to be. In terms of function, who are the beneficiaries of income? Anybody remembers? Who benefits from income?
The person's name by the trust, by the settler.
Yeah, the life beneficiaries, we call them, those who are expected to get X amount of money for their lifetimes. And then, of course, after the life interest passes on, whatever is left, whoever is been named to get the capital, the remainderment, remember them, they will be the beneficiaries of whatever is left, if
Yes.
anything is left. Okay, so it is no secret, or should be no secret, that remainderment are constantly watching to see what's going on, because they want to make sure that trustees are not wasting what should potentially be theirs at the end of the life income, receiving their benefits. And certainly they want to make sure that something is left if possible for them to get, and certainly their heirs, if they themselves are not available to receive. Okay, so everybody's constantly watching everybody else for obvious reasons. Money is a strange thing, even within trusted trusteeships. Strange things go on between trustees and beneficiaries, and they don't all follow the letter of the law or the requirements of the trust. Interestingly enough, we are reminded that the trustee is not under any duty to distribute. So even though the trustee is required under power, he does not have to. What is the consequence of not having to, of not actually distributing income and maybe even capital at some point? Clearly, we all probably know that by now. The result would be a lawsuit because the beneficiaries who feel that they are being not handled properly because of the trustee not distributing income and capital as appropriate, they are obviously going to bring action against that trustee to help them probably even removed if it's something that really persists. It's not something we should see too often in a trust relationship, trustee not distributing as required, but the fact that it's here suggests that there are instances where some trustees are busy accumulating income and capital and not distributing sufficiently to beneficiaries for whatever reason, especially discretionary trusts. Okay, we know the non-discretionary trust, there's no real issue there. You have to distribute according to the trust instrument, but for discretionary trusts, a whole lot of accumulation of income and capital could be made without actually being out of context. You might be out of favor, but you're not obligated as a trustee to distribute. Fascinating.
But a question here, but even in a discretion, well, I guess in a discretionary trust, he would have, it would be an express clause giving him the power of accumulation.
Well, maybe, maybe not. The problem is once a trust is declared discretionary, then we have to be careful how we put the process in that conflict with that particular ability to use one's discretion. That doesn't mean you cannot put it in, but it may not necessarily have any effect depending on the discretion that is available to the trustee, by all means. So typically under trust law, the trustee has to or is mandated to exercise his power to distribute trust assets and properties in accordance with the trust instrument. If he gets a directive from the instrument, there isn't any room and under those conditions for discretion. So I'm presuming in a case like this, we're talking about a non-discretionary trust, because if it's a purely discretionary trust, then the instrument per se cannot give a directive or should not give a directive as to how the trustee should behave. Which is why when we establish discretionary trusts, we have to be very careful the conditions of that trust, who the trustee is, and who's going to be impacted by the trustee's decision. Hence, the reason why we have a bunch of beneficiaries watching the situation all the time and the protector watching all the time. All of these groups are designed to, quote unquote, keep the trustee honest, even though you shouldn't have to keep a trustee honest. Because part of this discretion to exercise this power has to do with insisting and presuming that the trustee is going to act honestly and fairly and in good faith. Remember, that is the requirement of every trustee, without a question, no matter what type of trust it is. Honest, fair, and in good faith. And any trustee who fails to do that will face the music, depending on the situation. The goal of the trustee, no matter what we're doing, always is to protect and preserve the trust property at all costs. It's really quite as simple as that. So no matter how sophisticated the trust might be, no matter how much money might be in the trust, protect and preserve is the bottom line. And those trustees who are following that pattern very seldom find themselves in too much trouble. Trouble begins when we start moving away from the foundation, which is protect and preserve on behalf of beneficiaries. It's as simple as that. Usually, when the trustee is acting in good faith and exercising these powers within his discretion with regards to distribution of property, the law will protect that trustee, particularly if he's acting in accordance with the trust instrument and as permitted by the law. So again, it is not difficult to do this job per se, fundamentally, if you seek to do it the way it should be done. But of course, as usual, the majority of problems arise because persons don't always set out to do the job the way it should be done, whether they're trustees or even beneficiaries for that matter. Believe it or not, many beneficiaries do not act in good faith. Many beneficiaries create problems because of greed, because they don't like the trustee, because they don't like another beneficiary. So we have a whole lot of other variables that compete with this fundamental side of the trustee's work. But essentially, if the trustees following these fundamental issues, their jobs will be considerably easier. Okay? Considerably easier. All right. The Trustee Act also indicates that the trustee's powers may be either restricted or increased, depending on what comes out of the trust instrument, which is why it is so important, again, to always, that's the Bible of this work, keep the trust instrument somewhere that you can look and reference it at a moment's notice to make sure that you're acting in accordance with the trust instrument. Typically, if a situation arises in the trust and there's any doubt about how to act, the solution is quite simple, quote unquote. Pull out the trustee instrument, the trust instrument, and see whether or not there are any provisions. That's the point we should always start. A lot of trustees, unfortunately, do not always do that. Sometimes they make a decision on based on what they thought it was when they got the trust 7.5 years ago. And so they think that they have it right and act on what they think, not necessarily what's in the trust document. Some of them know exactly what they shouldn't do, but they go ahead and do it anyway because they have other ulterior motives going on. So trustees themselves are not exempt from being wayward and going contrary, certainly not. But fundamentally, we know what their jobs are supposed to be: protect and preserve. Robert, I see your name. Are you there? Robert logged in and went to the food store, I think. Then he'll be back. Robert, are you there? Okay, he will join us shortly. All right, so that's you, Robert? So the trustees' powers.
Yes, sir.
Okay, there you are. There you are. Great, great, great. Just wanted to make sure you were in the room.
Yes, right here. I'm currently still at work, but I just joined through my phone just so I could be able to tag along with the class today. I should be leaving
Okay,
shortly.
you're still at work. You guys still work long hours in the mine?
Oh, well, given the fact that I'm a sales officer, we have quotas to meet.
Oh,
And
you
then,
guys, you guys have quotas these days?
yeah, we have quotas. So the quotas is assessed quarterly. So every 3 months, we they would look at our results and how far we are for the quarter. And our quarters ending next week. So I just have to wrap up a few days on my desk. So I should be leaving you shortly.
No problem. It's that quota that I'm interested in. Who came up with the idea of giving a blanket quotas?
I'm not sure. I guess that's the way they'd be able to manage how you perform instead of you um just having the leeway to perform at your own leniency.
Yeah.
So they would then give you a goal to strive for, so you would at least have an expectation on what is required from you.
Okay, Robert, sounds good on paper. What happens if you don't meet the goal?
Or then they come up with an action plan where you can meet them moving forward, and then they go ahead and try other action plans. And then if you don't meet the quotas, and then you're not really improving. So it's also a part of it. If you're improving, then they can't really do anything with you. But if you're not improving and you're still at the same level, then they would then look at termination from there.
Now, Robert, I know exactly what you mean. So I'm gonna be the devil's advocate and raise a question.
Okay.
Uh, if you don't consistently meet some predetermined quotas that were pulled out of somebody's, I wouldn't say where, maybe their hat, uh, on a consistent basis, maybe 2 or 3 quarters, somebody could decide that the person is not adequate to fire you. Now,
Mhm.
the problem with that is, Robert, how can you determine in any real way how many people are going to respond to requests to come in for a loan or to open an account or to purchase a credit, get a credit card or whatever? How can you determine that at all?
So um, they have something called a sales platform, right? Where they would track everything that you would do daily. So if I contact the customer, as I contact the customer, I should be logging or giving a brief summary of what me and the customer discuss. So overall, in sales platform, they'd be able to see how much customers I contacted daily, how many persons I seen, like in terms of appointments daily. We are gold by 8 calls and 4 appointments every day. So overall, that's 20 calls and no 20. That's 20 appointments and 40 calls per week, right?
Yes, indeed.
And they also provide us with leads where you can go ahead and where they already have the customer pre-qualified. So basically, we just call the customer, and if they are interested, then if they accept the lead, then we go ahead with the application.
And
That's
if
a pardon.
and, and if they're not interested,
If they're not interested, then you make that notation on what why they're not interested and if they're interested in any other products and so forth like that. So it's a few different ways they track it.
indeed, indeed. So at the end of the day, then, uh, one is assessed on the number of contacts that you make in accordance with the protocols, or the number of customers who actually sign up.
Yes.
Which one?
It's assessed based on the number of calls, and then overall the amount of leads that you action, because they would give you around 100 leads every month of customers who's already been pre-qualified.
Right.
And out of 100 customers, if you contact 100, to their to the higher ups assumption that all 100 shouldn't say no. Out of 100, you should at least get 50% or at least 25% to say yes. So
Fascinating.
yes, so even if you don't get the 25%, you should get some kind of traction from the lead. So out of 100 customers, they're indicating that you shouldn't get no hits. Like it's no way that you didn't get anyone to say yes out of 100 customers.
Indeed, indeed. In other words, at minimum, make all the calls that have been allocated to you, period.
Exactly. At minimum, because if you're not getting any sales, we should see where you attempted to even try to go over and beyond to accumulate the sales.
Indeed, indeed. Well,
Yeah. So
I don't envy you guys at all. Uh, Back in the old days when I was a banker, we used to just sit in and busy ourselves until a customer comes in and says, I need. But things have changed.
yes,
I,
drastically.
not only from the customer's perspective, but from you guys who are now under the gun. So if you have
Yeah.
2 or 3 consecutive quarters, then you start to panic, and that's not good.
Yeah.
Yeah, indeed. 21st century banking. My.
Yes, sir.
All right, yeah, for sure. All right, so thank you for that, Robert. That's quite enlightening, actually.
Yes, sir.
So these trustee powers may be expanded or restricted under the Act and under the trustee instrument. And so the whole idea is that the trustee, the trust administrator, must be intimately involved uh, with the trust instrument, intimately involved with the trustee act. And when I say intimately involved, I don't mean they have to be personally swarming through these pieces of paper all themselves necessarily. Lawyers are usually on staff in a house or outside who can answer questions on the trustee act. And trust officers, etc., are available to make sure that the information on the trust instrument is clear and available, and to respond as necessary. So it's not that the resources are not there. The whole idea is to use them as effectively as possible to stay out of harm's way and to make sure that the trustee is carrying out the duties that are mandatory and the powers that are available and discretionary as prudently as possible, bearing in mind the P&P perspective: protect and preserve. Okay. All right. Again, words like discharge of duties and responsibilities efficiently and effectively, these fiduciary, protect and preserve, these kinds of words will always be and should always be in a trustee's vocabulary somewhere. If they're not, that's a problem somewhere, because they are the foundation issues with regards to the trustee's work. All right. Notice also that trustees themselves actually have what we call the full powers of the beneficial owners. They have full possession of the trust asset, but even though they don't own them, and they get to make decisions about how those assets are going to be invested, distributed, etc. They hold the real estate on behalf of beneficiaries and other assets, and so they have this power to borrow money, to vary certain agreements necessary to manage underlying companies. All of these things are discretionary powers that lie with the trustee, and they're all really designed to make the trustee as effective as possible in doing the job. And it's no wonder that this power of discretion has to be available, because if it was too prescriptive, the trustee would have a whole lot of trouble trying to do the job. And so it was allowed to be non-prescriptive, more discretionary, so the trustee is free within limits to get things done as practically and as quickly and as efficiently and as effectively as possible. Protect the beneficiary's interest at all costs. If you don't make a distribution, you should have a reasonable reason. If you don't, you're going to have a war on your hands anyway. If you're not carrying out certain activities that beneficiaries know are within your power, they're going to question you. They're going to have their attorneys call you. They're going to harass you until you satisfy them. Some trustees actually try to avoid dealing with certain beneficiaries to their detriment, because some beneficiaries are really mean and uncooperative and nasty dispositions, and some trustees and trust officers, etc., they actually try to avoid such beneficiaries. The only problem is they're not going to go away. So in real terms, when you have a beneficiary that's pursuing you, the best thing for the trustee to do is to deal with the matter head on. It's as simple as that. Deal with the matter head on. Because the more you try to avoid the beneficiaries, the more trouble you're going to have. All right. So much for my yapping for the moment. So if you look at the top of page 63, Robert, why don't you pick up with the reading for us, trustee minutes? Trustee minutes.
Page 63.
In my text anyway, hopefully it's the same in your text. It begins trustee minutes.
Trustee minutes. Yes, sir.
Yeah.
Okay. Trustee minutes are often used to document the reasons and discussions made by a trust committee for a professional trustee's discretion in the exercise of its discretionary powers. These minutes are protected from disclosure under the Trust Act 1998, as they are not considered trust property, subject to the beneficiary's right to information and access. With regard to the delegation of trust powers, the general principle is that a trustee cannot delegate his powers as to whom and what extent trust property may be distributed. However, a trustee may delegate certain duties and tasks in the administrative administration of trusts that may contribute to the exercise of trustees' power in the distribution of trust property. A trustee's power or discretion must be a positive mental act and must not result from his omission in or inaction. Additionally, trustees are not compelled to give reasons for the decision, particularly to beneficiaries. A trust must take particular care that his powers are exercised honestly, otherwise, and dishonest or improper exercise of his powers will invalidate it and any distribution made to the beneficiaries, depending upon the facts in every case. Equally important is the fact that trustees must exercise their discretion within a reasonable time with which again depends upon the facts of every case. Other circumstances regarding the time and type of exercise of the power discretion may determine whether it will be validated or not. The exercise of a trustee's discretion must be done fairly and independently, and a trustee must not be seen as a nominee of the settlor or a puppet on a string. Should, should the trustee act solely and exclusively by the instructions of the settlor and not act independently, the trustee may be declared as sham in many offshore jurisdictions, particularly in the instance where revocable trusts exist and give the settlor very wide powers to control and dedicate the trustees and the trust.
Great, thank you very much, Robert. So let's look at a few key points before we, we move on to trustee remuneration. It's a very interesting area. Couple of things before we move on. As we discussed before, the trustee minutes are for the purposes of the trustee and not the beneficiary. Robert, I think your phone is still open. Your mic.
Okay, my apologies.
No problem. So no matter what the beneficiaries might say, the trustees are protected in terms of the trust minutes. They don't have to show any trust minutes to the beneficiaries. They are protected from disclosure under the Trustee Act. And in the majority of cases, they are protected under the trust instrument. Typically, if we have a trust instrument that does not protect minutes, a trustee might have a concern with that and seek to have the trust instrument amended because the trust minutes typically represents the representation of how the trustee is thinking, and no trustee wants to get into any exchanges with beneficiaries on what the beneficiaries thought his thoughts were and why his thoughts were related to his thinking and his thoughts of the thought before the thoughts. That you can see right away, that's confusing in and of itself. Okay. And this particular right has been preserved throughout the centuries for obvious reasons. Other information is accessible to beneficiaries, but not those minutes. With regards to power delegation, the trustee can delegate his powers to anyone he wants, but he cannot delegate the responsibility. So if he hires an investment manager and they mess up, the trustee is responsible. He hires a lawyer, they mess up, the trustee is responsible. He hires an accountant, they mess up, engineer, whomever. He can delegate his powers to anyone, but not the responsibility. It's quite as simple as that. And so the trustee cannot go to the beneficiary and say, it wasn't me, it was the investment manager that caused the investment to fail. So this power of discretion then comes back into the discussion, and we are told once again that this discretion that the trustees have, this power of discretion, must be a positive mental act. Very specific words. The trustee must not fail to act, must not leave his actions out on purpose because he's afraid, or he doesn't want to, or he doesn't like a beneficiary. Whatever the reasons are, he cannot do it. He has to act, he has to invest, he has to maintain, he has to ensure, he has to do all those things that a prudent man would do to protect and preserve the assets. It's really as simple as that. And even though they're not compelled to give reasons for their decisions to beneficiaries, they have to act with care. All the more reason why they have to act with care, and why these powers have to be exercised honestly with integrity, for obvious reasons. A big time job to be a trustee. The very word itself. Unfortunately, trustees are not all as trustworthy as they should be. And that is something trustees and non-trustees need to keep in mind, including beneficiaries, and they do. That's why they're constantly watching, and that's why we have protectors. Because left alone, even trustees can become untrustworthy, have become, and are untrustworthy as we speak somewhere. Hopefully not a great majority of them, but everyone that is a big problem, for sure. Also, and very important, discretion cannot be exercised whenever the trustee feels like it. The time that he acts must be reasonable. What is reasonable? The circumstances will determine what's reasonable. It's in his discretion. But if his time is taking too long in terms of a beneficiary and they start getting restless, they might take the matter to court. And if the court rule can see that you really took longer than it should have taken within the normal scheme of things, you as a trustee can find yourself in hot water, paying damages of one kind or another. Because I don't like that beneficiary, let them wait. I hate a mother, she was my ex-wife, whatever it is, or ex-husband, whatever the case might be. That's not an excuse to be unreasonable with getting things done on behalf of beneficiaries. And so at the end of the day, we're reminded, be fair, be independent. Any trustee who's not doing that, if they have any favorites, if they like one beneficiary over the other, they have to keep it a secret, they can't act on it. They are required to be fair and independent at all times. Must not be seen as a nominee. Anybody knows who a nominee is? Who's a nominee? Google it. Who's a nominee? Anyone?
Well, we can give an example of nominees. When companies are formed, they're nominee shareholders.
What meaning what?
Well, they're actually not beneficial shareholders, but a nominee, I guess we're looking at a nominee more in the vein as an agent. And
Yeah, a nominee represents, but they're not the actual thing. Okay? A nominee in name only, but they're not the actual beneficial owner. They're not the actual individual. So in this case, where we are told that a trustee must not be seen as a nominee of the shareholder, meaning that he must not be seen as carrying out the instructions of the settlor. Sorry, not shareholder, settlor. Because once the trust has been created, the settlor should be quiet. Unfortunately, that is not always the case, especially under modern trust law. A lot of settlers have far too much authority, far too much power within the trust, and this is where the question of a sham trust comes in. If a beneficiary or beneficiaries notice or detect that a trustee is being managed and run by a settlor, they can then bring an action before the courts and declare the trust to be a sham trust and therefore to be shut down and a new trustee or trustees nominated. Okay, so it's very important that there's no perception by beneficiaries that a trustee is being manipulated, is acting as a nominee or mouthpiece, but really the settler, even though they're in the background, is actually the one making all the decisions, at least all the important ones. What is a revocable trust, anyone? Revocable trust.
A revocable trust can be changed, amended, or just simply revoked all of the conditions. Just
Yeah.
shut down.
Yeah, revocable means the settlor pretty much is in control of the trust and they can shut it down whenever they feel like. As opposed to the irrevocable trust. Once you set it up, that's it. You have a change of heart, too bad. If you decided you made the wrong decision, too bad. Does it mean there's nothing you can do? Typically, no, but not entirely. Remember, you can take anything to court. And you can go before the judge and rip your shirt off and throw down your heels and say, I made a mistake. I really don't want this to be an irrevocable trust. And who knows? On some bright sunny day in the Bahamas, some judge might be persuaded, but not too often. We certainly don't see those very much at all. Which is why once the settler decides on a settlement, he has to be very clear on what his intention is and what he is seeking to do. Because once it's done, it's done. All right. So let us move on then to unit number 7. And this one is an interesting unit because it talks about money. How the trustees to be paid. Should the trustee be paid? When should the trustee not be paid? Why would the trustee want to be paid at all? And so on. So remuneration is a very sore point, very exciting point within the life of the trustee and the beneficiaries. Now, sometimes there's some beneficiaries that feel that some trustees are getting paid too much. Why? They're thinking if the trustee can get paid less, then they can get more. So they might bring an action even to say, hey, the amount of money that this trustee is being paid is too much. And remember, when stuff gets to court, it can go either way. Which is why, typically, if you can get the issue of remuneration built into the trust instrument, that might help. But that's not a guarantee that action will not be brought against you should a beneficiary find out how much you're being paid as a trustee. How can the beneficiary find out? Anyone? How much the trustee is paid?
Well, I would look at the financial statements.
Yeah, look at the annual financial statements. That might tell them because, financial statements can be quite elusive sometimes depending on where stuff are actually listed and under what categories and under what name. But some beneficiaries have become quite keen themselves. They'll get a financial statement, but they have their own accountant. They're not trying to understand it. They will pay their own accountant and say, I'm paying you to tell me what the hell is really going on. And to raise the appropriate question about the information in the financials and the disclosures. Disclosures do not always mean correct. Disclosures do not always mean sufficient. And disclosures certainly do not always mean honest. So, 21st century beneficiaries are an interesting group of characters, right, for sure. And in some cases, they have to be. The 21st century trustees are an interesting group of characters as well, when they decide to act out of their fidelity position. All right, remuneration. Let's see who wants to talk about. Odeka, are you there?
I am, sorry.
There you are.
I am.
There you are. Okay. Can you see unit 7, trustee remuneration?
I can, yes,
Okay. Can you?
a trustee may change
Go ahead.
You want me to read?
Absolutely.
A trustee may charge for his services to the trust without being in breach of his fiduciary duty, if the trust instrument expressly permits him to do so. The charging clauses in trust instruments are strictly construed by the courts. Reed Chapel, 1884, and Reed White, 1898. A trustee must ensure that the trust instrument allows for remuneration before acting as trustee, so that his services are adequately considered and duly compensated. The express statement of remuneration in the trust instrument is the most optimal way in which the trustee can be assured that his remuneration is authorized.
Mhm. Keep going.
Express charging clause in the trust instrument will be allowed, even though it may enable a trustee to exist for duty and interest. Space Investments Limited and Canadian Imperial Bank of Commerce Trust Company Bahamas Limited, 1986, and Sargent and National Westminster Bank PLC, 1990. Even though there is a charging clause in the trust instrument, the trustee may only charge what is reasonable. A trustee is entitled to recover out-of-pocket expenses from the trust estate if they are legitimate. Such expenses include litigation costs or paying fees to agents, Spate and Gaunt. If a trustee takes funds from the trust in excess of what is reasonable, he may be sued by the beneficiaries for breach of trust.
Wow.
The court also has jurisdiction to authorize the payment of remuneration to trustees for past and future services to the trust, notwithstanding the fact that the trustee may have accepted the unpaid office prior to rendering his services. Bainbridge and Blair, 1845. In exercising its jurisdiction, the court will consider the following information, as in the case of Reed Duke of Norfolk's Settlement Trust. 1, the protection against claims of the trustees, particularly in light of the gratuitous of their office. 2, the trust, the experienced developer. The jurisdiction of the court may be exercised to give a trustee remuneration either for past or future services, or to increase the remuneration of a trustee where the level is unacceptably low. Additionally, as in the case of Keeler's Settlement Trust 1981, the court also has inherent jurisdiction to permit trustees to keep remuneration they had taken in breach of their fiduciary duty and ordered an inquiry as to future remuneration for some of its trustees. Notwithstanding the fact that such agreements are rare due to allegations of undue influence which be made against them, trustees may contract with beneficiaries who are sui generis and absolutely entitled for remuneration. Such beneficiaries will be bound by these agreements. Ailiff and Murray, 1740. Where trust assets are situated abroad, the law of the country where the property is situated or is located allows trustees to receive remuneration, and trustees under Bahamian or UK trust. That ain't make no sense. Receive such remuneration. Something missing. They will not be bound to account for it unless they went out of their way to obtain it. Read Northcote's Will Trust, 1949. As a corollary to the remuneration of trustees is the rule in Keach and Sanford, which states that a trustee must not allow his interests and duties to conflict. Additionally, a trustee is not allowed to take any profits from his position as trustee unless these profits have been authorized by the trust instrument. The beneficiaries who are sui juris or the court, Boardman and Phipps, 1967. Similarly, a trustee cannot purchase trust property for himself. Well, duh. Tito and Waddles, 1977. This is not a duty imposed on trustees, but a disability. Any purchase of trust property by a trustee at the instance of a beneficiary will be voidable, no matter how fair, open, or honest the transaction may have been. My goodness.
Yeah.
Clearly not a fiduciary duty.
Thank you so much, Decker, because now we see a whole different perspective in terms of the money side of things for trustees. What is especially astonishing. Sorry? Yeah, what is especially astonishing initially is that typically trustees are not allowed to charge for their services. It's fiduciary, it's typically free. Originally, when you became a trustee, you were not paid for your work. You did out of good faith, the goodness of your heart. You're a sweet guy, you're a relative, you're somebody they know. You promise to look after stuff, not take some of it. And so the work of the trustee was essentially free. The work of the trustee is still free, quote unquote, which is why, especially if you're a personal trustee, if you're a professional trustee, it'll never be free because professional trustees will never sign off on anything that's going to be free. They're not going to incur the cost of managing the trust without earning any return on there for their work. Okay? So typically we see free trustee work more prevalent with individual trustees, and sometimes some individual trustees who can be a family member, a lawyer, an accountant, or any such person who the settlor leaves the settlement with, they might discover that this job that they took on free initially is taking a lot of their time, using a lot of their personal resources, including their money. And so even though the individual trustee is under no obligation to get a fee, in some cases, that individual trustee may be forced to go before the courts and say, hey, I took this on as an attorney, that's my friend, that's my sister, that's my brother, that's my auntie, sister, child. And so I took this on in good faith as a trustee. But along the way, I've incurred these expenses. And if you can prove to the court that those expenses are burdensome and you have evidence, don't go in talking without evidence. That won't work. But if you have evidence to prove that you spent X amount of money out of pocket to maintain
Come off, people. Are you having?
this trust,
Sorry. Let me ask you this question though.
yeah,
So even if they're an individual trustee, if they understood what their role would be prior, it seems kind of counterintuitive for them not to say, okay, I agree to be a trustee, but I'm not going to accept any, I mean, the individual trustee.
yeah,
You'd think that they would consider that. I mean, especially those ones, you have individual professional trustees out there too.
sure. If the trustee is a lawyer, accountant, business person, some such person who has information and knowledge of how this works, it is very unlikely that they will take it on without proposing a fee, a charge of some kind, unless they really are doing it out of the goodness of their hearts. But typically, those kinds of trustees. Then we have other trustees who are quote unquote ignorant about what's going on. They are so happy to do something for their auntie, sister, child, and the children who are under 18, etc. I'll look after them. Yeah, I'll do it. And they really don't understand the remuneration side of things until their pocketbook, for example, start to hurt. And they're like, wait 1 minute, this thing is costing me more than I needed to cost. And so what's going to happen? They're either going to start dipping into the trust fund of some kind or get some information, some advice, and find themselves before the courts to seek some kind of remuneration, okay, for the monies that they have to incur, if it's deemed to be excessive by the courts. Because you might go with your invoices in the courts, my man, that's not enough to convince me that suggest that you should get something out of this trust. But again, every case is unique, every judge is unique, and every decision typically will be slightly different from the one before. Okay, for sure. So it's a kind of tricky situation with remuneration. And so it's important. Professional trustees don't have that problem. Individual trustees who are professionals typically don't have that problem. The only person who might run into some problems with regards to charges is that person who's really doing it out of good faith and then starts to struggle because they really didn't know, they were ignorant of the implications. And there are a couple of individual trustees over time that have found themselves in that position, unfortunately. Okay, Irie, are you there? Irie. Oh, audio issues. Okay, no problem. You made it. All right. Then, on the other hand, the court can then step in and authorize payments where there was no arrangement for payment. Again, if it can be determined that the argument for remuneration is reasonable. In fact, the court may even rule that all past expenses, present and future expenses will be covered by the trust, given the basis of the evidence presented to the court. Remember, anything can happen in the courtroom. That's the problem. So be clear on what your objectives are before heading into court, because courtrooms themselves are unpredictable, for sure. At minimum, unknown until the final verdict is made. And oftentimes, for someone, it's not the right one. But if a trustee is feeling aggrieved because they're not getting any money for the work or not enough, they can take it to court, and sometimes they are successful. The court will look at certain things. Is this trust an important trust? Who are the beneficiaries? What would happen if this trustee should decide to step down? We have to get new trustees. Will the new trustee be as informed and as efficient and as productive and as concerned as the one who needs to be remunerated? All kinds of questions can come up. What about the skill level of the current trustee who needs to be remunerated versus the one who might come and say, oh, you don't need to pay me, but not being paid, does that mean you're going to get substandard? It can get pretty messy if it's not put in perspective pretty quickly. And of course, remember, anytime these kinds of matters go before a judge or a court, the first thing that should be in the judge's mind or the court's mind is the beneficiaries. Whatever decision we make, it must be in the best interest of the beneficiaries. That's the deal. It gets pretty tricky sometimes, especially when you take a matter to court to get past, present, past. That's even more tricky than anything else. Current, and then future, maybe. And again, it all depends on your arguments. What arguments are you presenting to the court to support your position to be remunerated as a trustee, professional or individual? They took a moment to remind us that these situations tend to be rare, and part of the reason for that is most professional trustees, if not 99.9% of them, will not seek to pick up a trusteeship without being remunerated, period. The one problem that they might have is they might discover a couple of years into the trust that their remuneration is too low, that they were so happy to get the trust, they forgot to realize that the returns on the investment for doing the work is not sufficient, it's not covering the costs. It's not profitable for the trustee. And so something of that nature might drive a trustee to court. And so your honor would say something like, aren't you getting remunerated now, Mr. Trustee? And he'd say, yes, your grace, but I'm afraid the current remuneration is insufficient to cover my costs. And I am not even breaking even with this trust. Hence, I'm requesting a 30% increase to cover my additional costs, as well as to earn a small return for the profit on this particular investment. And if you can present enough information to persuade the judge, he might even agree. If you can't, dog eat your lunch. You either live with it or you give up the trusteeship. And we saw earlier, giving up trusteeship is not always as easy as you think. There's a process. There's some steps involved that you have to go through. The other 2 points of interest under remuneration are conflict of interest issues. Trustees are required to stay away from conflict of interest issues. Do not take profits from the trust or its underlying companies unless you get approval to do so. Period. Don't say nobody's getting hurt. I'm just getting a little more of my share. Don't say I've been working much longer hours, and even though I get my remuneration, it doesn't cover all this extra time and effort that I put in this trust. So therefore, I'll make a few bucks on my own on the side from my affiliation with this trust. You're not required to do that. A couple of cases everywhere will tell you you're not required to make profits from the trust. In some rare cases, as I mentioned in the previous session, you can go to the beneficiaries and say, I would like to do X, Y, and Z because of my affiliation with the trust. And as a result, I expect to make a more profit from it, which will not directly impact the business of the trust. And so I'm bringing it to your attention for your approval. If all of the beneficiaries approve, say, yay, we love this guy or girl, let's approve it. Then go ahead and make some profits. But if even one beneficiary disagrees, dog eat your lunch. If you go ahead with it, that one beneficiary finds out, they will wreak havoc on the trustee. It's quite as simple as that. Purchasing trust property for oneself, the trustee, it's a no-no. Another conflict of interest. Even if a beneficiary tells you it's okay, that's your friend, one of the beneficiaries, oh, it's okay, I'm the most influential beneficiary, you can do it. And it's discovered, the whole transaction can be made null and void. And if there were any losses to the trust, you would have to cover them. And if your luck is really, really bad, you may lose your trusteeship and all the millions that you're making in trustee fees up to that point. No such thing as a straightforward situation in the world of trust management. It is very fundamental in nature, but very dynamic in practice, as I'm sure you've seen already.
I had a system that phone, it wasn't charging, even
Hugely.
though I have it.
All right. Irie, you still having problems with your doggone it, that bloody mic. Okay. So William, that just leaves you then. Are you there, William?
I didn't hear, what are you saying?
Irie is having difficulties with her mic trying to get it on. And so that just leaves you to cover the reading on retirement and removal of trustees,
Okay.
beginning with retirement of a trustee.
Retirement of a trustee. A trustee may retire by an express clause in the trust instrument under section 47(2) of the Trustee Act by the beneficiary sui juris or by the court. A trustee may retire without a replacement if there are at least 2 trustees or a trust corporation. He may also retire where the existing trustees consent to his retirement, or the trustees may execute a deed of retirement. Where the requisite consent cannot be obtained, the court has the inherent power to discharge the trustee without a replacement. A court will discharge a trustee provided there is at least one other trustee who will continue to act as trustee of, or a new trustee is capable of being appointed to the trust. This equitable principle is to ensure that the trust continues to operate in the best interest of the beneficiaries, taking into consideration the nature and extent of the trust. A trust instrument may contain an express power which allows a trustee to retire. Additionally, there are provisions in the Trustee Act 1998 which also permit a trustee to retire. A trustee may retire by obtaining the consent of all beneficiaries who are sui juris and between them absolutely entitled to the whole beneficial interest in the trust. Another way for a trustee to retire is to obtain the consent of the court. A trustee who seeks to obtain the consent of the court to retire from a trust will be required to pay the cost of the application for such discharge, except in the instance where he has demonstrated to the court that the trust has changed significantly from his initial appointment and or acceptance to act as trustee of the trust. A retiring trustee of a trust normally requests a release from liability in relation to his trusteeship, which he may be granted on termination of the trust. Where a new trustee is appointed upon the retirement of a trustee, the release from liability may not be granted depending upon the circumstances. Removal. The court may also remove a trustee where he is unfit to act, refuses to act, incapable of acting. The court can remove a trustee without replacing the trustee. See Letterstead versus Brez, 1844, case 371. The removal of a trustee by the court is normally based upon the actions of the trustee, which may be due, I guess, to some dishonesty
Yeah.
for which he may have been formally convicted, or some financial irresponsibility with regard to the property and his trust, or by him becoming a bankrupt. A court may also remove a trustee from a trust where there is found to be continuing friction between the trustees and the beneficiaries. Example, for substantial overcharging by the trustees, and the fact that the trustees would have a difficult task of administering the trust in the best interest of the beneficiaries if left to continue to act as trustees. Letterstead versus Brez, 1884. In the case of Visa versus Chase Manhattan Corporation Limited, 1994 Supreme Court, the Bahamas, number 1261 of 1992, unreported, the court suggested that to remove a trustee, there should be proof shown of some misconduct. Suggested that to remove a trustee, there should be proof shown of misconduct or mismanagement of the trust assets, and not merely that the beneficiaries are unhappy. In this case, 4 of the beneficiaries sought the removal of the corporate trustee as the company did not sell the 49% interest in the partnership as directed by the settlor, who was given power so to direct in the trust instrument. The discussion centered on the trustee's standard of care, Spate versus Gaunt, in which the judge stated that it is not indeed every mistake or neglect of duty or inaccuracy of conduct of trustees which will induce the courts of equity to adopt such a course.
Right.
Well, it's spelling curse, but I suppose it's course.
Yeah, it looks like a clause, right? Yes.
Yeah.
Mhm.
The acts or omissions must be such as to endanger the trust property or to show a want of honesty or a want of proper capacity to execute the duties or want of reasonable fidelity. The court held that it was in the best interest of the court to remove the trustee, as the trust had 6 years before it came to an end, that the asset had been liquidated and disbursed to the beneficiaries. Additionally, the decision in MacPhail versus Dalton reiterated the principle that if trustees are unable to administer a discretionary trust, the court could appoint new trustees to do so. A trustee may also be removed under a power within the trust instrument or by statute. The circumstances surrounding the removal of a trustee under a power within the trust instrument must be clearly related to the power of removal, since the power will often be strictly construed, and the removal of a trustee may impact negatively on the trustee from a moral standpoint.
Thank you very much. And so, as quote unquote simple as it might seem on paper, in context and in practice, it could sometimes become far more gray than it is appearing before us. The thing that is especially important is that the trustee, first of all, can be removed by the trust instrument or statute, provided the instrument and statute is clear on the removal process, and provided that the circumstances actually is the result of what we see in the instrument or in the act that allows for such a removal. Notice we are also reminded that courts have the ability to remove trustees for all kinds of different reasons, based on the trustee's actions. For example, if the trustee is found to be dishonest, courts look very dimly upon dishonesty by a trustee by the very nature of the name and work and responsibility of the trustee. So if he is found to be financially irresponsible, personally or otherwise, he's become bankrupt personally, or somewhere, some companies running, whatever the case may be. These things will be looked upon very negatively by the courts, and such a trustee could be removed for these reasons. Okay. One of the other key points that was mentioned in the Chase Manhattan case, etc., in the Bahamas, is that this issue that has to do with administering the trust in the best interest of the beneficiaries, and any activity by the trustee that could interfere with that process, that could be sufficient for a court to decide that a particular trustee should be removed. We're given a very interesting example where the beneficiaries gave an instruction to sell an interest in a partnership. The trustee, for some reason, did not do it, and so they took him to court. What is also interesting is the judge's perspective that, hey, the trustee should not be removed just because they made a mistake or neglected a particular duty. The situation, in order for it to be equitable, has to be such that it endangers the very foundation and trust property under the stewardship of the trustee, or that the trustee is showing a want for honesty and proper capacity to carry out his work and reasonable fidelity or faithfulness in his task. In other words, unless the trustee is failing sufficiently in these areas, the court may not see reason to remove that trustee. So if you had a bad day and you got angry with the trustee because he didn't agree with something you said or wanted, and you bring a case against that trustee, that is not going to hold up in court. You have to, you being the beneficiary, would have to bring a rather substantial case for a trustee to be removed, as it should be. The work of the trustee is far too important for there to be trivia in the environment, and some beneficiaries are quite trivial. Okay? They don't care. All they want is what they want, and greed and emotions and all this crazy stuff often kick in and cause beneficiaries to do all kinds of unsavory things with regards to a trust. And so trustees have to be well informed, well ready, quite capable of meeting these kinds of challenges. And of course, in the earlier part of William's discussion, a trustee might retire. However, he doesn't just get up and sign a retirement letter. I'm retired, see you. There are certain steps that he has to go through. There's a certain issue of liability, where sometimes outgoing trustees may not want to sign a liability clause in incoming trust. Is like, are you kidding me? You want me to come in and be responsible for your mess, John? Please sign on the dotted line and date it. And take a copy, whatever the case might be. The incoming trustee must do this in order to potentially protect themselves. It doesn't protect the incoming trustee 100% because even though a past liability might come up, it could be connected to a current negligence on behalf of the new trustee, and then suddenly the old thing comes to haunt the new trustee, despite the liability clause. For sure. Courts are hardly interested in discharging a trustee if there will be no trustee available to replace that trustee. Okay. It would be a rare moment in hell for a court to make that decision. If there are other trustees, one or more, they could work with that. But if a trustee is walking away or resigning, for example, or retiring, and there's no successive trustee available there, no others, the court may very well direct and instruct the trustee to not leave until there's a replacement. And if the trustee so decides to leave, they can be found in contempt of court for not following the instructions of the court. All again is designed to protect and preserve the interests of beneficiaries. It's a solemn promise. Okay. And courts will take it to the end to preserve that promise, if necessary, which is why typically the final recourse is always the courts, because prior to that, people have all kinds of things going on, trustees and beneficiaries and protectors and everybody else, suppliers, agents, everybody has something going on that can create conflict.
I just have a question on this.
Yes.
Can you hear me?
Yes.
Is it normal for a court to confer with beneficiaries when replacing trustees as to, a selection as to who may be suitable to be, to be named as trustee?
I'm sure that matter could and would come up, perhaps in some instances, through the beneficiaries' attorneys, by all means. Whether or not the final decision will be based on what the beneficiaries think is another matter. But again, certainly at some point, the trustees will have the ability to say, here's who we would like to be a trustee. And the courts may or may not go with that, depending on who that might be. But definitely it's available to them to present it. Because I remember at the end of the day, whoever's presented, there has to be somebody that the court feels has the temperament to be the trustee that beneficiaries need to protect the trust assets. And that's ultimately the court's final and only position. So that when the matter is closed, that trust is protected once again. By all means. All right. Any other questions before we look at the assessment questions? Yeah, quite a bit of food for thought in any event. And these units happen to have been, all of the units are important. These units happen to have been pretty key units among the others, because the issue of remuneration and power and duties and retirement are very key issues that have to do with the management of the trust, the personalities in the trust, and the succession planning for a particular trust. So these are very key units to the issue of trust management that goes very well and even beyond some of the other aspects of trust administration. They're all important because they all come together to make this thing work. But certainly, if we were to look at some key areas, these would be some of those key areas for sure. All right, anybody have an opportunity to look at the assessment questions? No?
Yes, yes.
Okay, I definitely did. All right. The question, unit 5, you were able to get to unit 5, Adeka?
Let me go back. Five. Let's see if I put it here.
Unit 5.
Yeah, so, sorry, I'm there now. General requirements to act as a trustee. Sound mind,
Yeah,
legally declared a bankrupt.
yeah, not declared actually. Mhm.
Yeah, not there. It says not legally declared, so we can call somebody broke, but until the court tell them they broke, they ain't broke.
Correct. Very, very typical situation. Okay, anything else? Not legally declared, have sound mind,
Legal age,
must
sui
be, a-
juris, I guess, at least 18 years old.
yep, sui juris, yes.
Um, high level of integrity, trustworthiness, commercial awareness, and due skill in care.
Yeah,
But I
definitely,
don't, yeah.
they are definitely the general requirements for any trustee, okay? Individual or professional. Certainly, for the professional, they expect to carry all of these things to the next level. The individual trustee are expected, at least fundamentally, to have some hint of these characteristics. All right, number 2, what is required for a corporation to act as a professional trustee in the Bahamas?
It must be, must be either licensed, from the central bank, by the central bank, either restricted or non-restricted license by the, so the legalities must be met in that they must be properly incorporated. They must be licensed by the central bank, by either a restricted or non-restricted license.
Yeah, the key is for a trustee, you are required to get the license, but it either has to be declared restricted or unrestricted, because each of them have very unique characteristics in terms of how the trust is to be managed. Okay. All right. Number 3, what are three circumstances in which a trustee may be appointed? What are the 3 circumstances in which a trustee may be appointed?
Oh, I didn't realize that. Sorry. The creation of a trust,
Yep.
as a substitute of a trustee who has died or retired or
Yeah.
been removed, and as an addition to an existing trust that already has a trustee.
Absolutely, absolutely. Hopefully your colleagues speed writing. Number 4, what document is typically used in the appointment of new trustees? Which document?
Deed of
Uh,
appointment.
Yep, the date of appointment. Yep, the date of appointment. Number 5, beneficiaries are required to be blank and blank to be able to appoint a new trustee. Beneficiaries are required to be blank and blank to be able to appoint a new trustee.
I would guess that sui juris is sui juris and absolutely entitled, eh?
Yes,
Proprietary interest.
sui juris is definitely one of the issues. And what's the other one again?
Proprietary interest in the assets of the trust. They must have a proprietary interest.
Meaning?
That they have the rights with relation to the trust arise by virtue of the property in the trust.
Indeed. Without that, they can have no say. Okay, in fact, they would not even be declared to be beneficiaries. All right, number 6, what consideration does a court make in seeking to appoint new trustees? There are a couple of them. What considerations, plural, does a court make in seeking to appoint new trustees? What do they think about? What do they consider?
Whether they have jurisdiction,
Jurisdiction, yes.
They have to consider the welfare of the beneficiaries and interests of the beneficiaries.
By all means,
They have to consider whether how the trustees acted, whether it was proper or improper
yes,
or dishonestly. And the nature of the duties to be performed by the trustees and whether such duties were of a particular personal or delicate nature.
Mm.
That's on
Any
3.
Any others that we can add to that? Those considerations. What about the wishes of the settlor? Is that important?
I almost want to say yes, it's important, except I'm thinking about the fact that the letter of wishes is not even binding on the trustees themselves.
True.
But yeah.
True, but it is supposed to have some influence, and some of that influence could very well work if a matter gets before the courts. In this case, it's kind of like if you're married and you say to your spouse, if something happens to me or when I die, I'd like for you to do these things. And then they say, sure, hon. And then after you die, you expect them to do it. They might not. But that's kind of what the letter of wishes are all about. You hope they do it. You tell folk what you'd like for them to do, and then the rest is up to the circumstances, by all means. What about impartiality of the new trustee? Is that important? Impartiality.
Yeah, because they're supposed to be, they shouldn't have because their duty is owed to the trust itself, they shouldn't have a partiality, I guess, to any particular beneficiary.
Definitely. Which is why the question that came up earlier about can a beneficiary suggest a trustee? It might come up in a rare moment, but that will impact impartiality to a great extent, and therefore we may not see too many of those as a result of that. Because a typical beneficiary is going to pick somebody that they want, that will be typically in their interest. Doesn't mean, sorry, a trustee, doesn't mean that that trustee will not be a good trustee. The point is they're connected to that beneficiary somehow because they made the suggestion. So impartiality is crucial so that the new trustee is not connected in any form or fashion typically to any of the beneficiaries. That's the ideal situation. 7, what action should the trustee take prior to appointment of a new trustee? Prior to the appointment of a new trustee, what action should he take? Make sure that the new trustee is
What's that word?
fit and proper. Maybe that's
Yeah, it's right, fit and proper.
fit
Fit
and
and
proper
proper.
these days. That would certainly be one point to consider. And secondly, ensure that the appointment is made in accordance with the trust instrument. But keep yourself out of hot water. Number 8, what action should a trustee take after appointment as a new trustee? Quite a few things. Once you become
Should review the trust instrument to ensure that he's aware. Is it prior or yeah, after appointment? After being appointed, yeah.
Review
Take
the
actions to ensure the preservation, protection of the trust assets. So review the instrument so that he's aware of the specific terms of the particular trust and knowledgeable about the provisions in the trust to avoid a potential breach of trust action.
engage.
And review and inspect the trust documents accompanying the trust instrument, inclusive of the trust accounts, notices, memoranda, trustee minutes, etc.
Definitely. Anything else should the new trustee do?
That the trust, ensure that the trust instrument has been legalized properly. That includes the stamping and recording.
Yes, make sure it's properly constituted for sure. Otherwise, you might go ahead as a new trustee without of an official trust. That's a whole other problem. And then, of course, let's not forget the responsibility to invest. That a lot
Yes.
of discussion doesn't sitting around investments, but it's a very important part of the trustee's responsibility with regards to preserving the assets of the trust, by all means. Number 8, what is a trust duty? How much trust duty is required to stamp trust instruments in the Bahamas? What is a trust duty?
It's $50 under section 92.
Okay, that's the amount. What is a trust duty itself?
That's
Yeah, it's that amount, remember, that we pay in order to validate or properly constitute the trust.
yeah.
Yeah, that's the pay to the registrar generals.
Indeed, or else pay the $50. I'm surprised it's only $50. Am I the only one that's surprised? Here's
I
another-
certainly, I'm surprised because they don't have no problem taking that 10% VAT off you when you try to get some real estate done,
Not at all.
of the value of the real estate.
Not only
And these
that,
trusts, some of these trusts are,
yeah,
some of these trusts are millions of dollars.
yeah, millions a decade. I've been saying that
Yes, millions.
from my here was black men. What are we doing? What are we doing? Even if we do a progressive charging level, where if the trust is up to $1 million, it's $50, let's say, and then or whatever, and then $1 million to $5 million is doggone $2,000, some stupidness like that, and then 10 million like that.
Well, you know, the Companies Act is now being changed to increase certain taxes and fees that you're going to pay to the Ministry of Finance and the Registrar General's Department. And I just attended an industry briefing on the new law that's coming in. So I expect that there's going to be some changes concerning trusts as well, registration for trusts.
I hope so, and I hope that it affects substantially those who can afford to pay for a change. See, that's the point. All these bloody potholes and trips to Dubai we need to make, they need to increase. Yeah. My. Some of these rates we've been charging since Columbus discovered the New World for millionaires. Hold on it. Okay. Number 10. Why is it important to inspect previous breaches of trust after appointment of a trustee? Why is it important to inspect previous breaches after you pick it up?
Because a new trustee succeed to the old trustees, and whatever the old trustees were liable for, the new trustees become liable for. So inspection permits the new trustee to at least become and be indemnified by the old trustees against any claims, etc., that might have arisen against the old trustees.
At least to the greatest possible extent. Some indemnities will be accepted and covered, but depending on the liability and the situation, the indemnity may not be recognized, and the current trustee himself could find himself dealing with an old liability. Okay, unfortunately, just like when people get remarried, sometimes one of the two persons who get remarried, if they were married before, they bring some heavy burdens into the new marriage, and if you're not careful and you don't get rid of them, you don't work it out, you bring the liability, so to speak, into the new situation. It causes a lot of problems. Same thing with the trustee. Okay, by all means. All right, unit 6. Anybody did unit 6? Self-assessment.
Yeah, but I want to allow somebody else to talk.
Okay, somebody else. Robert has been quiet. Robert, are you still there? Said, man, I'm calling customers. My
Yeah, I'm still here. I'm still here. I'm still here.
Did you have an opportunity to attempt any of the answers in unit 6?
For the assessment on unit 5, no, sir.
What about unit 6?
Unit 6? No, I haven't gotten a chance to do that as well.
I know that bloody quota keeps you under the gun, whether you realize it or not. But I'm just teasing. It's totally crazy. I
Yeah,
know
but
how it is.
thankfully I'm going on vacation the following week, so that was the time I actually set to go over everything again,
Nice.
just so I'll be up to par with all of the subjects at hand for the exam.
Sounds good. I would encourage you to take a few moments to complete any self-assessment questions you haven't, because
Okay.
they help to take you back to the future to see some of the stuff and help to solidify them in your mind. So make sure you attempt them as part of your review process.
Okay.
Okay, so Jacka,
Yes, sir.
looks like me and you, kid. Um, I haven't heard anything from
Oh,
William. I assume he may not have gotten all this crazy stuff. And Iris,
I've done it.
you finished?
I've done it.
Oh, okay, unit 6. Okay, William. Then let's see what William has. Number one, a trustee has a duty not to place himself in a position where his blank and blank conflict.
We basically talking about his personal interests.
His interest and his,
I have all the questions reference a position where duty conflicts with
ah,
their personal interests.
okay, so duty is the first one and interest is the second one. Okay.
Yeah.
Number two, what are the general duties of a trustee?
General duties of a trustee, I have that on page 59. The management duties,
Yes,
administrative duties, and duties of propriety.
absolutely, absolutely.
Management duties, which includes the investment management and distribution of trust property. Administrative duties reflect trustees know and carry out the terms of the trust, and the proprietary duties must act honestly and appropriately.
Indeed.
Must not act dishonestly and inappropriately.
Those are the three duties, yes, of every trustee. All right, number three, what is the difference between a trust and a duty and a power? You have trust, but that should be duty. What's the difference between a duty and a power?
Um, the, the nature of a trust involves a trustee holding the legal interest in property. That's the legal interest, and the power is where a person owns both the legal and equitable interest in the property.
Now, that's interesting that you recognize the legal part of the question, but you remember also there's another part of the question in terms of trustee duty and power. That being the duty is a mandatory behavior that you are required to do. It's not optional, and that the power is optional and discretionary within the trustee's discretion. So those two points are attached to the legal aspect of the duty and power of the trustee. All right, number four, what are considered profits for a trustee acting in administration of a trust? How does the trustee make profits while he's administering a trust? Profits he shouldn't make unless it's approved.
Let's see what I have for reference now. Apparently, I didn't answer that one.
Yeah, I think one example they gave was the receipt of director's fees, where the trustee is sitting on the board of an underlying company and being paid, even though they're actually the trustee of the company, that's the underlying company. That would be considered profits for the trustee. Also, any misuse of information for the benefit of the trustee would be considered profits. Any profits that are earned because of inside information would be considered profits. earned by the trustee. Remember, we are told that they're not required to make any profits unless those profits are specifically approved by each and every beneficiary, which will be hardly ever. Number 5, the Trustee Act 1998 gives the trustee power to insure himself against blank, except for breach of trust in the administration of trust.
It's trustee can be sued personally, so he can insure himself against that
Yeah,
Right.
personal liability, yes.
personal liability, but not
Personal liability,
Yeah,
breach
personal
of trust.
liability.
but
Absolutely,
not for breach of trust.
no. Not for breach of trust. All right, number 6, a trustee is required to exercise his discretion honestly, fairly, and in
Good faith.
faith, yes. Number 7, what are used to document a trustee's deliberations regarding his decision to distribute to a beneficiary?
Minutes.
3 minutes, yes. Number 8, a trustee power or discretion must be a blank and not an omission on the part of the trustee.
Not express.
The acronym of PMA.
Trustee's power or discretion must be a positive mental act and must not result from his omission or inaction.
A positive mental act, absolutely. Number 9, a trustee, yes, we must act fairly and independently and must not be seen as a blank or blank for a settlor.
Nominee of the settler or a puppet.
No.
Number 10, if a trustee acts solely on the instructions of the settlor without acting independently, the trust may be at risk of being attacked as being a
Sham.
trust. Yes, yes, yes. All right, wonderful, wonderful. Moving right along, unit number 7. Okay, well, you know what? I'll just read the question and somebody can shout the answer. All right, number 1, a trustee is allowed to be remunerated, that should be, for his services if the blank expressly allows it.
Trust instrument.
Trust instrument. Number 2, in exercising its jurisdiction, what information will a court consider?
Protection against claims of the trustees, particularly in light of the gratuitous nature of their office. How well the trust is being administered, with due regard being paid to the nature of the trust, the experience and skill of the particular trustee, the amounts which he seeks to charge compared to what other trustees might require to be paid for their services, and any other circumstances which may be relevant.
Indeed, indeed. And so that would be the judge's position, again, to make sure at the end of the day, if there's fairness and equitable circumstances surrounding the management and the decisions we made regarding trust. Remember, the judge's position is simple as well. The trustees, the beneficiaries' interest must always be protected no matter what. Okay, everything else is secondary. Number 3, the court's jurisdiction may be exercised to allow a trustee to be compensated for blind or blind services to the trust.
Past or future.
Past or future, yes. Or a trustee may enter into agreements with beneficiaries who are blind and blank to be remunerated from the trust fund.
Sui juris and absolutely entitled.
Absolutely. Number 5, what is the general principle regarding trustee remuneration related to assets situated abroad?
They will not be bound to account for it unless they went out of their way to obtain it.
Indeed. So remuneration is allowed, but you're not bound to account for it unless. Okay. What is the unless again, Odeka?
Sorry,
What is-
unless you went out of your way to obtain it.
Yes. Out of your way is a tricky expression, isn't it? And we'll leave it tricky. All right, we'll leave
No
it.
underhandedness.
Number 6, under the rule in Keach versus Stanford, Sanford, a trustee is not permitted to allow his blank and his blank to conflict. You just saw that.
Duty and interest.
Duty and interest. Number 7,
Duty and interest, yeah, that was.
a trustee is also not allowed to take any blank from his position as trustee if not allowed by the trust instrument beneficiaries who are sui juris or the court.
Take
One
any
word,
profits.
profits, yes.
Profits.
Blank in the trust instrument will be allowed even though it may enable a trustee to gain from his fiduciary position and even though it may produce a conflict of duty and interest.
Each in Sanford, he'll be allowed to take it, which is what it says, blank in the instrument.
The key point is that even though it may enable the trustee to gain from his fiduciary position, and even though it may produce a conflict of interest. I know that's a tricky one. It actually should be authorized.
I was about to,
Oh, you were-
authorization in the trust instrument.
Yes, yes. In other words, even though it may create these unusual situations, if it's an instrument, that's it. We're bound by it unless what is in the instrument is going to create a situation that is so egregious that it should be allowed. And of course, in that case, the court will make the decision as to whether or not it's egregious. Other than that, once the instrument authorizes it, for example, if there's a disabled child and the trust instrument does not make any provision for the disabled child, technically, that should go as it is. However, if somebody's disabled, that is going to be considered egregious if there's no provision for that person. That particular case, no doubt, will end up in court 99% of the time, right? By all means. All right, number 9, a trustee cannot purchase blank for himself.
Trust property.
Trust property.
Properties, yes. Number 10, any purchase of trust property by a trustee at the instance of a beneficiary will be blank, no matter how fair, how open, or honest the
Void.
transaction has been. Yes, it'll be void. And whoever loses money, too bad. You're not supposed to do it. No matter how fair. All right, and finally, unit 8. Have a look at that quickly. Anybody got to 8?
Yes.
Okay. Number 1, this instrument may contain a blank, which allows a trustee
Not
to
an express clause.
express clause. What does express mean?
It's stated.
Yeah, written, stated, in writing, not stated with our lips.
In writing.
Yeah, absolutely. Because whatever lips say, lips forget quickly, don't they? Yes.
Yes.
When I used to be the deputy managing director at a Brazilian bank some years ago, my boss, who was the managing director, he was Brazilian. He never wanted me to write him. He always wanted to chit chat. And of course, he must have known that I knew that chit chat can be easily forgotten. And so, in my discretion, whenever I had an important matter, I would write, and he would always get fussy about it. Samuel, why you keep writing? His English was not that great, by the way. Why you keep writing? Let's talk. And then the next time I'd write again. So he was pretty pissed off for a long time. But things that can be easily forgotten that are important, you could chit chat, but they should always be expressed. I'm sure Jack and William and others know exactly what I mean. All right, number 2, what are 2 other ways in which a trustee may retire?
Where there, well, I guess both of them are the same thing, but where there are at least 2 other trustees, and there are existing trustees.
Oh, I see.
Uh,
Approaching
yeah,
it from that angle. Anybody has another angle? Remember remember when we say what are the 2 other ways, that means that number 1 was the first way. And then there are 2 others.
Yeah.
And so those 2 other ways should be by the beneficiaries unanimously and by the court. Okay. So the 3 ways together express, there should be an express clause in the trust instrument. The beneficiaries must all agree, or the courts may so direct. Okay? And then everything else comes under those categories and their respective positions. Number 3, a court will discharge a trustee blank, or a new trustee is capable of being appointed to the trust.
If there's at least 1 trustee left.
Yes, at least 1. Remember the rule, the position of the court, we cannot leave the trust what? Uncovered. Okay. Number 4, a retiring trustee of a trust normally requests a blank from liability in relation to his trusteeship, which he may be granted in termination.
But a release from
Release.
liability.
Yes, a release from liability. Number 5, with regards to the removal of a trustee, the court has blank jurisdiction to remove a trustee and appoint a new one to replace him or remove a trustee without a replacement.
Inherent jurisdiction.
Say it again?
I thought it was inherent jurisdiction
Yes, that's a word we can
or
use.
discretion.
That's another word. Sometimes people just use the other word, final, but they are used interchangeably. Okay. Number 6, the removal of a trustee by a court is normally based upon the actions of the trustee, which may be due some blank, for which he may have been formally convicted, or some blank with regard to property under his trust by him becoming a blank. What's the first blank? Due to some,
Misconduct.
yeah, dishonesty or misconduct. Second blank. Convicted of some, the convicted or some,
Formally convicted of some financial irresponsibility.
yes. And then finally, by him becoming a
Bankrupt.
bankrupt. And as Odeka said earlier, you're not bankrupt until the court declares you to be bankrupt, even though half the country and half the world or more might be technically bankrupt. As we speak, unless the court declares it, let no one call you a bankrupt. How's that?
And Mr. Wilkinson,
Hi.
some people call it bankruptcy, bankrupt, other people call it insolvent.
Yeah. Suddenly, there's a thin line and a gray area with regards to solvency and bankruptcy. Right? My. Okay. Number 7. What are 2 other ways in which a trustee may be removed from a trust? I know that one doesn't jump out at you.
Is it because of the friction between the trustees and beneficiaries, where there's found to be a continuing friction between trustees and beneficiaries,
Yes.
or the trustees might have a difficult task of administrating the trust in the best interest of the beneficiaries if left to continue to act as trustees.
Yes. The only catch there is the trustees' inability to administer a discretionary trust. Why do you think he might have a problem with a discretionary trust as opposed to a non-discretionary trust?
Well, with the non-discretionary trustee, he doesn't have that responsibility.
No, it doesn't. Just do what it says.
Mhm.
The problem is once you're given discretion, well, things get a little gray, don't they? Anyone? Discretion. Discretion is a marvelous thing, but it is also a very destructive tool for trustees and everybody else. In my discretion, I decided to order that he be shot because I hate his mother. Say discretion is a crazy thing.
Yeah.
Okay, for sure. Even though we have a non-discretionary rule in the Ten Commandments, thou shalt not kill. Every day we exercise what? Discretion. Yeah, we don't check for the non-discretionary rule. All right. Number 8.
What was the second one? What was the second one? You say friction between trustees? What was the first one? I'm just trying to jot this one down because I didn't get.
Yeah, friction with beneficiaries.
Uh-huh.
And secondly, inability to administer a discretionary trust.
Okay.
Right? Number 8.
I think I think this is a trick question because it really should be if the trust instrument provides for removal and inability to administer the trust to the best interest of the beneficiary.
that can certainly be added and it will not be incorrect. Okay,
Okay.
this trust instrument so instructs by all means.
Okay.
Number 8, a court may also remove a trustee from a trust where there is found to be blank between the trustees and beneficiaries.
That's a friction.
Yeah, continuing.
Continuing.
Yeah, and there's a reason why we use continuing. An occasional disagreement or friction is not sufficient grounds. And even if a beneficiary takes that to court, the judge might well throw it out. Look, do not bring any bloody trivia to my court. If you have friction, make sure it is substantive. I have enough murders on my hand or something. All right, number 9. If trustees are blank, a discretionary trust, the court could appoint new trustees to do so.
The
That-
trustees aren't able to administer the discretionary trust
Unable to administer.
if they are
Unable to administer, yes. All right, number 10, the circumstances surrounding the removal of a trustee and their power within the trust instrument must be blank, since the power will often be strictly construed, and the removal of a trustee may impact negatively on the trustee from a moral standpoint.
It must be related to clearly related to the power of the court of removal.
Clearly related to the power removal, okay, without a doubt. And if it isn't, then the judge will make the decision in his discretion that he thinks is the best decision. But with regards to the instrument, clearly, not just related, clearly related, so that there's no ambiguity involved in the process. All right, fantastic. What can I say? You guys were amazing. The time went too fast for the 3 sessions we had. It was absolutely great. And I wish you guys every success in your final examinations. Any questions before we break?
No, I'm just happy I got 3 weeks to study, well, 2 and some weeks to study.
Absolutely. So here's what you do. Set up your plan and start this weekend. Do not procrastinate. How's that?
Indeed. There's so many cases to learn and parts of the trustee act to learn, so definitely.
Remember, you're not going to remember all those crazy cases unless you ting them or ting them down. Here's what you do if you're not exceptional, and only 1% or 2% of us are anyway. The cases, find a way to summarize them so that you are dealing with the key issues. What's the opening, what's in the body, and what's the conclusion of that case, how it relates to the trust issues at hand. And kind of summarize them and then study your summaries, dealing with the key aspects of the case in connection to the relationship of the case to the trust situation at hand. If you do something like that, it will make for productive study, and it will make your study of cases a little less stressful. Okay? But again, at the end of the day, whatever works for you individually must first take priority. All right? Good luck. And
Yes,
if you need to find me, you know where to find me. I'm always available, notwithstanding. And if I can be of any help, feel free. Okay?
thank you, thank you.
Take care.
Sure. Enjoy
Have
the
a
rest of
great
your
night, sir.
Take
Bye-bye.
care, Robert, Harry. Good night. William, Rebecca.
Yes, sir, good night.
Good night.
Right.